Okay, hey guys, welcome to today's Fiveable stream. As you know by the title of the stream, we're going to be going over some of the required Supreme Court cases that you're going to want to know for when the AP test comes along in May. So we'll just get right into it. So if you're not already following Fiveable on their social media, it's at Think Fiveable on Twitter, Instagram, on YouTube. So just go and do that because they always have updates on who's going to be streaming what. So if you want to know when a stream is happening, that's a point where you can check. In this stream, we're going to be talking about the required Supreme Court cases. And so there's 7 of them. And so Roe v. Wade, Gideon v. Wainwright, Wisconsin v. Yoder, New York Times versus the United States, Schenck versus the United States, Tinker v. Des Moines, and Engel v. Vitale. So hi, Dan. Thanks for tuning into this stream. So we're going to just jump right in. And so the first case we're going to be talking about is Roe v. Wade. And Roe v. Wade is a case that comes up a lot just in the news. And you guys might already know that it's about abortion. So some background about the case is that there was this woman whose name was Jane Roe. And so that wasn't her real name. It was just a fictional name used to protect her identity because it's about abortion. And so that's a very personal health issue. And so she filed a lawsuit against Henry Wade. And so he was the district attorney of Dallas County in Texas, which is where she lived. And so there was this law in Texas that made abortion illegal unless a doctor ordered it to save a woman's life. So Quinn is asking, is this the same stream as the one from a week ago? And yeah, we just updated some of the content and we're going to have the slides because last time we didn't have them. So yeah. It's obviously very restrictive when it comes to abortion if you can only access one if your doctor orders it. And so Jane Roe was arguing that this was unconstitutional and the law is very vague. And so she was arguing that the right to abortion is protected under the 1st, 4th, 5th, 9th, and 14th Amendments. So that's obviously a very broad argument, right? And so what ends up being the ruling is that the Supreme Court says that because of the due process clause of the 4th and 14th Amendments, saying that a woman cannot get an abortion is a violation of their right to privacy. And so that right to privacy and that clause of the 4th and 14th Amendments, they protect a pregnant woman's choice to have an abortion or not. And so the Supreme Court also says that this isn't something that's absolute, and that they will have to balance the government's interests in protecting a woman's health and protecting the potentiality of human life. So the Supreme Court does recognize that it's not a completely absolute right to abortion, right? But they also recognize that if a woman does want to make a choice for herself, then under the Constitution, she does have that right. And so they struck down the law and said that that law was too vague. And so, guys, remember, if you have any questions, make sure to drop them in the chat or to click the Ask a Question button so we can clear up any confusion that you guys might have. But that being said, just to make sure everyone's keeping up with everything, what right protects a woman's right to abortion? And so make sure to answer in the chat. Okay, so we'll just go over it. So the right to privacy under the 4th and 14th Amendments are what protects a woman's right to abortion. And so that was a ruling that came out of the Supreme Court case Roe v. Wade. And so the next Supreme Court case we're going to be talking about is called Gideon v. Wainwright. And so some background for this case is that there was a man named Clarence Earl Gideon. And so he was charged in the Florida State Court with a felony. And so he requested that the court appoint a lawyer for him. But Florida had a law that said an attorney can only be appointed to someone who's too poor to afford one. So the trial court didn't actually give him an attorney. And so he had to represent himself in trial because there was no lawyer to do it for him, obviously, right? And so he ended up being found guilty because if you're someone who has absolutely no legal experience and you have to defend yourself in state court against someone who's a career prosecutor who's been prosecuting criminal cases for like a decade or more, then you don't have the best chances and like most likely, right? So he filed a petition to the Florida Supreme Court and he said that the trial court like violated his constitutional right to have counsel and to be represented by counsel. And so that's something that's protected under the Sixth Amendment. And so the ruling that the Supreme Court ended up giving was that, so some background, the Florida court ended up the case ended up at the Supreme Court because it dealt with constitutional law. And so he also appealed to the Supreme Court. So the Supreme Court ruled that state courts have to appoint attorneys for defendants who can't afford to retain counsel on their own. So they said that because the guarantee of counsel is something that's fundamental under the Sixth Amendment, they're going to use the 14th Amendment to apply that to the states. And so if you guys remember from our stream on the 14th Amendment, something that it helps do is called incorporation. And incorporation, selective incorporation, is this idea that the rights that are protected under the Bill of Rights, which only applies to the federal government, are also slowly applied to state governments. So the Supreme Court bundled the 14th Amendment and the Sixth Amendment together, and they said that states also have to give attorneys to those who cannot afford them. And so that's what the Sixth Amendment says. It guarantees the accused right to assistance of counsel in all criminal prosecutions and requires that the court provide counsel if the defendants can't get one themselves. So, question for you guys. What does the state have to provide to all defendants in a trial? And so this is in the case that they can't actually afford them or have access to them for some reason. So Quinn says it's a lawyer. Yeah, and so Quinn is right. If a person can't afford representation or for some other reason can't get it, the state has to give it to them because it's difficult to guarantee fair trial if people don't have the resources to build a case. So this next case that we're going to be talking about is called Wisconsin v. Yoder. And so this is a Supreme Court case that is very, it's based around religion. And so these people who end up being the defendants during this case are named Jonas Yoder and Wallace Miller. And so they were part of the Old Order Amish group. And so it's just a sect of Christianity. And another person named Aiden Yutzi. And so he was part of a group that was made up of conservative Amish Mennonite people. And so they were being prosecuted because Wisconsin had this law that required all children have to go to public school until they're 16. So you can't pull your child out of the public school system if they're still under that age. And so these people that were part of these Amish groups, they were refusing to send their children to school after the 8th grade because they were saying that high school attendance in this case was contrary to their religious beliefs. So sending their kids to high school past the 8th grade would be something that's not part of their religion. And so they didn't want to go against that. And so Wisconsin was prosecuting them because they were saying that you're breaking the law by not continuing to send your child to public school. And so this interaction ended up going to the Supreme Court, as all of these cases did. And the ruling ended up being that individual interests in the free exercise of religion under the First Amendment would outweigh the state's interest in forcing these children to go to school after 8th grade. And so one of the reasons why the Supreme Court said this was because Wisconsin and the state was saying that there were going to be these like benefits of education, like these huge benefits that the students would get because they were still going to school after they were like in 8th grade, right? And so the Supreme Court was like, they're not really seeing what those benefits would actually be. And so there's no real justification for that law because of it. And so the Supreme Court ruled that the reason why the Amish children didn't have to go was because of the fact that they were allowed to practice their religion how they wished, but then also because the values and programs of secondary school were in conflict with the life mandated by the Amish religion, right? So it really did like conflict with how they were told to practice their religion. And so it wasn't just an excuse to not send their children to school. It was an actual lifestyle that they were supposed to be living that they couldn't because of this law. So yeah, that's why if you live in Wisconsin and you are a person that is part of this religion, you don't have to go to school after 8th grade if that's what your lifestyle and your like parents like dictates. So, question for you guys. So Wisconsin v. Yoder said children don't have to go where if it violates their religion. And so you guys can just say the letter answer in the chat. And so A is school, B is the grocery store, C is the police station, and D is Congress. Okay, so Quinn says A, school. And yeah, that's right. That's exactly what Wisconsin v. Yoder said. It said that under the First Amendment, you're allowed to exercise your religion and practice it however you choose. And so if your religion says you shouldn't go to school after like a certain age, then you don't have to go to public school. Okay, so this next case we're going to be talking about is New York Times versus the United States. And so the background for this case was that there was this thing called the Pentagon Papers. And so the Nixon administration tried to stop the New York Times from publishing these materials. And so the reason why they tried to stop them was because they were from this classified Department of Defense study about the history of the United States activities during the Vietnam War. And so they were saying, at least the United States government was saying, that prior restraint was necessary to protect national security. And so prior restraint is this idea that you can stop something from being like published in the press before it actually is like published. So if like there's some information that's like incredibly like it might endanger lives or something like that, then the government can like stop that from happening with prior restraint. And so the New York Times obviously was saying that like, hey, that's a violation of like free speech, right? Like there's freedom of the press in this country. And so the ruling ends up being that the government didn't actually overcome the heavy presumption against prior restraint of the press. So like the Supreme Court and rulings in the past have said that it should be difficult for the government to like stop things from being published under the guise of national security, right? Because they don't want the government to be able to say that something is national security every single time just because it's like potentially politically unadvantageous to them, right? And so the Supreme Court said that the word security shouldn't be like, it was a very vague idea. And so it shouldn't be an idea that's like used to erode the First Amendment. And so in this case, they found that because the publication of the papers and like the story that the New York Times was trying to publish wouldn't cause immediate inevitable and a direct event that would put American forces in danger, prior restraint was unjustified. And so this is also the case that led to like a really big emphasis on like the the industry of like the news industry being able to like publish things that are considered to be in some cases like classified, because if they're not actually like harming national security, then there's no reason that prior restraint should be exercised. And so, question for you guys, is everything that the government says is a national security matter, does it have to remain unpublished? Okay, so Rumaya says no, and she's right, because if the government could cry national security every single time something like regarded something to do with the government, then it would be something that's very like bad for freedom of the press in this country, right? Because we want to make sure that the press can like express opinions and like keep the government in check, rather than the government being able to like censor anything that they say is national security just because it might portray the government in a harmful like manner. So this next case that we're going to talk about also has something to do with the idea of national security. And so this case is called Schenck versus the United States. And so the background behind this case is that it happened like in the period of like World War I. And so there were these two people, and they were socialists, and they were named Charles Schenck and Elizabeth Baer. So they were handing out these leaflets that were saying that the draft that the United States had like instituted violated the 13th Amendment's ban on involuntary servitude. And so the draft, in case you don't know, is when pretty much the United States requires like people to like join the military or the armed forces, right? And so like after you turn 18, like all boys have to like sign up for the draft. And so it's not like completely like required that you end up going into the military. But if like there's a time of war, then the federal government can like institute the draft again and like require certain people to like join the military. So that's what the draft is. And so the 13th Amendment was passed to like abolish slavery. So that's why it banned involuntary servitude. So these two people, Schenck and Baer, said that the draft, because it was like these people weren't voluntarily joining the military and they were being required by the government to do so, it violated the 13th Amendment. And so in these pamphlets, they were urging the public to disobey the draft and to do it peacefully, but to not join in case they were drafted, right? And so Charles Schenck was charged with conspiracy to violate the Espionage Act of 1917. And so this act says that you can't cause insubordination in the military and try to like obstruct recruitment. And so obviously, if you're trying to like have people disobey the draft and not join if they are drafted, then that's obstructing recruitment. So that's why he was charged. And so this ended up going to the Supreme Court. And the Supreme Court ruled that the Espionage Act didn't violate the First Amendment, and it was a valid exercise of Congress's wartime authority. And so the reason why they said that it didn't violate the Espionage Act was because Schenck and Baer were saying that by arresting them and charging them with like this crime under the Espionage Act, that they were violating their right to free speech. And so because the Supreme Court ruled that it wasn't a violation, then they could still be charged. And so that meant that Schenck and Baer's actions were still considered to be illegal by the Supreme Court. And it also said, the reason why the Supreme Court said this was because there was this idea that during wartime, they should have greater deference to the government, even if constitutional rights were at stake, right? So the Supreme Court in this case is pretty much saying that if the government is trying to do things during wartime to like protect people, then the court should give them more like leeway even if they're violating constitutional rights in the process, right? So this meant that Schenck ends up like still having to like have his actions be considered illegal. And so in that case, during like the First Amendment in a case regarding free speech, the Supreme Court ended up ruling in favor of like limiting it. So the important thing to remember here is that the Supreme Court doesn't have a perfect record when it comes to like protecting free speech rights. Like there are cases in which the Supreme Court says things are too much. And so whether or not you feel that was the right decision is completely up to you. But what I'm trying to communicate here is that the Supreme Court isn't an entity that always like expands freedom and expands rights. Sometimes it does place limits and checks on those rights. And so they instituted this idea of the clear and present danger test. And so what this test pretty much is that it says that the First Amendment doesn't protect speech that would cause danger. And if it would cause danger, that would be clear and it would start that danger like in that moment. Congress could prevent that speech from happening because they have an interest in making sure that all people's livelihoods are protected. And so this is where that famous comparison where like yelling fire in a crowded theater is like illegal happened. So they compared the leaflets to shouting fire in a crowded theater. So it would cause like a danger in that people would like freak out and start like running towards the exits and people could get injured or like trampled in that like huge crowd of people and all like the ruckus and the fear, right? And so they said that in those cases, there would be a limit to the First Amendment. And so, yeah, they ended up putting that limit right there. So the next case we'll talk about is called Tinker v. Des Moines. And so this case is about a group of students in Des Moines, obviously. And so they had this plan to show their support for a truce in the Vietnam War. And so the way that they were going to show this truce is by wearing a black armband on their arms, like during Christmas. And so they weren't planning on doing like anything else, like nothing like particularly disruptive. They were just gonna like go about their school day wearing these armbands. And so the principals of this Des Moines school district found out, and they made a rule that said that any student that would be wearing an armband would be asked to remove it. And if they didn't remove it, they would be suspended. And so it's important to remember here that this rule was made specifically because of this group of students' ideas. It wasn't something that was in place before the principals had found out about their plan. And so on December 16th, these two children, Mary Beth Tinker and Christopher Earhart, wear their armbands to school. And because of the policy, they're sent home. And on December 17th, the exact same thing happens to John Tinker. And so the students don't end up going back until New Year's, which was when they like planned on ending their protest anyways. And so their parents supported them in their like wanting to have their right to free speech. And so the students sued the district for violating their right to expression and free speech. And so they also wanted to avoid being punished because they didn't do anything that like you would consider to be like punishable, right? They just wore black armbands. And so the Supreme Court ends up ruling in this case that students don't lose their First Amendment rights to freedom of speech just because they're on school property. And so they also said that school officials would have to be able to prove that whatever speech was being like conducted, that behavior would interfere with the operation of the school. So if you were doing something that's like disruptive, so like standing up on a desk and yelling that like you're completely opposed to light bulbs. I don't know why we're protesting light bulbs in this case, but we just are. That would interfere with operation of the school. You're disrupting a lesson from happening because you're standing on a desk and yelling. So in this case, the school district didn't have like their actions come from like a real interference. They were just scared that something would happen. And so the Supreme Court said that you can't actually just stop free speech from happening because you're scared there will be a disruption. There actually has to be a disruption for you to like limit free speech. So in this case, the Supreme Court protected freedom of speech in school for students. So, simple question here. Are students allowed to protest at school? And so A is yes and B is no. And so you guys can just answer in the chat. Okay, so Quinn says A, yes. Students are allowed to protest at school unless they're doing something that's like disrupting school while they're protesting. So this last case we're going to talk about is called Engel v. Vitale. So this case is about prayer in school. And so the New York State Board of Regents said that a voluntary prayer that was like proposed could be recited at the start of each school day. And so the prayer was, Almighty God, we acknowledge our dependence upon thee, and we beg thy blessings upon us, our parents, our teachers, and our country. So this could have been something that's like completely innocuous, but the important thing to remember here is that like not every single person in New York was following the same religion at this time. So a bunch of different organizations joined together, and they said that this prayer violated the First Amendment's Establishment Clause. And so the First Amendment's Establishment Clause says that the state, aka the government, federal government, could not establish a federal religion or like an official religion or like encourage specific religions or discourage other religions, right? And so that they were saying that by like having this prayer at the start of each school day, they were kind of endorsing a specific religion. And so the Supreme Court ended up ruling that the government can't hold prayer in public schools. And so it doesn't matter if like it's voluntary participation or it's not like related to a specific religion, the government just isn't allowed to hold prayer, period, in public schools. And so that meant that the recitation of the official prayer violated the Establishment Clause because public school, because it's funded by the federal government, or not the federal government, by state governments, and like that, like local and state governments are like pretty much the state, right? So it violates the separation between church and state because religion isn't supposed to influence the way that our country is governed and how laws are made, right? And so that means that public schools are an extension of the government, so they can't have like any specific prayers being recited. And so that was the ruling that came out of that case, right? And so fun fact, in a lot of different places in the South, we still have like, we say the pledge and there's a moment of silence. So if you want to pray during that moment of silence, you can. And so it doesn't mean that like, this ruling didn't mean that there's like absolutely no way to pray at school. It just meant that the school couldn't like have a voluntary prayer that would like be said at the beginning of the school day. So that is the end of our 1st through 10th Amendments required Supreme Court cases. So if you guys have any questions, make sure to answer them in the chat, and I'll just wait like a minute or so in case any come in, and after that, I'll sign off. Okay, so it looks like there's no questions, but a quick reminder, AP Government is always streaming on Tuesdays and Thursdays And on Monday at 7:30 p.m. Central, we have our current event stream along with the AP Lang team. And so if you want to learn more about what's going on in the world, or if you find the news confusing, make sure to tune in because we break it all down for something that's understandable and you can write about in class. Okay, bye guys. Have a good night. Thanks for tuning in.